We're going to talk about several topics today. Most of them are going to be focused on process types of issues, not necessarily scoring issues as we have in the past. And the reason for that is some changes that are coming that we want to inform all of you as care coordinators about. That's also why we have chosen to try and do this video conference this way, so that as many care coordinators hear this firsthand versus going through your care coordinator, train the trainers. So we're going to cover very quickly a category called not met pending type review, EPSDT exceptions, the growing number of appeals, some daily report guidance, open enrollment changes that are coming, which we've had multiple emails about that this week, ongoing concerns that we picked up from you all, and then some good news about scoring improvements. So let's begin by talking about the not met pend review recap. If you participated in the September review, we gave you a preview of an opportunity that we were developing called Not Met Pend, which enables you as a plan to take and submit an annual LOC, and then if they do not meet criteria, they would be sent back to you for the opportunity to fix an error or make a correction or do an update that has occurred since you did the LOC. We're going to talk about those clarifications, some notification scheduled things, and actions that you're going to need to take as a plan. So, what is the pen review process? I've kind of hinted at it a little bit already. You will submit your annual LOCs just as you have in the past through the portal. The portal will process them at the end of the day. I'll say 9 o'clock at night just for the purposes of this conversation. And then it will produce an email that will announce the results of that day's input by your plan and send you that email by the next morning. So if you submitted information Monday, Tuesday morning, you're going to have an email in the LOC box that will tell you the results of the plan, of the submissions that you made. It will tell you who met, who didn't meet, and how many did have the opportunity to resubmit. That's what the not pen or the pend review is. The pen review is the opportunity, again, for you to make corrections to the plan. Here's the catch. You have 3 business days to do that again for it to be considered. You'll see it a little bit better later on as I go through the flow chart. If you submit it after the 3 business days, we are going to automatically use the original submission, because everything has to be very time limited in terms of our processing things so that we can avoid any delays and things. This is a slide that we showed last September regarding the LOC process. I'm going to walk through it again today to provide a clear example of what we mean by the not pen process as well as normal LOC processing. So as you can see, the first box provides you the opportunity to go out and do the annual face-to-face LOC. Then you put the information into the portal, which is on the Virginia VMAS portal. You will then print that information, and then once you close it, the portal will accept the data. It's at this point that the portal, at the end of that day, like I said earlier, say 9 o'clock in the evening, it will transmit that information into the LOC system. The LOC system will then do some basic reviews to validate information, which is these steps. Then it will go forward and actually conduct an automated review of your submission. That automated review of your submission will determine if the person meets criteria or does not meet criteria. Here's where the not met pen category comes in. If they do not meet, the LOC system is immediately going to send you an email that tells you this person did not meet, they are pending. That means that kicks in the first business day of the 3-day business period for you to do an update to your LOC. If you submit the updated LOC within those 3 business days, you submit it in the portal just like you did the original one. If for some reason you choose not to do one, that's up to you, and we will use the original one. So if you do a resubmission, We go back through the standard process again. It goes through the portal. So let's say you submitted it on the second day, 2 days later, it'll go into the portal, it'll go through the staging, and it'll go through a second automated review. If the second automated review makes a determination that they meet, the process ends. If the second automated review determines they do not meet, that's when the clinical staff, the RNs here at DMAS, will begin the higher level of reviews. The RN level review will result in two things. One, they will override the review. They will do that after they've made conversation, consulted with you regarding information or questions that they have. And if they don't override it, then we will move towards disenrollment for the person. So as you can see, it's quite sequential, it's quite logical. You all have the opportunity to look at it twice before a final disenrollment is made. Now, to give you an idea of what that report will look like, this is a sample of the daily submission that you will be receiving. So this, I think, as I go through it in a little bit more detail, you will begin to see there's a tremendous amount of information here, and it will be critical that you have your central person emptying this box every morning, not at 11:59 a.m., more like 8 or 9 in the morning, to give your team the maximum opportunity to do any corrections that you might want to do during that time. So allow me to kind of highlight I lost my cursor, the headers. Where'd my cursor go? It's on my screen here. I know where it's going. All right, the headers which are in the green. It will provide you the individual member's name, their social security number, their Medicaid number, and their date of birth. This obviously will give you the basic information on the individual. Then the assessment date that it was due, then it gives you the form completion date of which you submitted it. Then it will provide you the results of the first automated review. Okay, did they meet or not meet? Okay, if they met, if you scan down that first column where it says first automated review, you will see down towards the bottom a bunch of Ys. So what we have done is we've set this format up so that anyone who did not meet on the first automated review are at the top of the list. So that hopefully saves you some time searching for which ones are not pended and have the opportunity for a second review. So moving to the next column, first automated review pended, not met. The plan can resubmit. Those are the N's with the asterisks. Those individuals will be sent back to the plan immediately so that you have the opportunity for submission within the 3 days. The next column says health plan response to pended reviews to be within 3 days notice of pended. That column will say you did not submit within 3 days or you did submit within 3 days. So again, remember I said earlier, the timing of the 3 days is important that you get going on it as early as possible. The next column to the right, second automated review determination on plan, secondary review, did they meet or not meet? Now, let's look at the very first row. The first automated review penned said they did not meet. The plan then chose not to resubmit, so there was no action or no second automated review, and it automatically goes to the higher level review by the DMAS RN. If you look at the second row example, again, the person did not meet on the first automated review. The plan did resubmit something, and the plan did change the information, and the person did meet criteria. Therefore, there is no action needed by DMAS RN staff. Going down to the third line, the plan said the person did not meet on the first automated review. They did not submit anything. The second automated review, there's no action because we go back and use the first one that was submitted. The RN staff at DMAS looked at it and they overrode it. So the person stays enrolled in the waiver. Now we move to the fourth row to give you an example. the plan initially said in the automated review they did not meet. Then they resubmitted it. On the second automated review, they did not meet. That means then it went to a secondary higher level review by the DMAS RNs. They did not meet there. So essentially, we have reviewed this person's case 3 times and determined that they did not meet. And then the next column, non-eligible reason, tells you why they did not meet. And it tells you that we are going to move to discharge this individual from the waiver. So I kind of back up and repeat myself. As you can see, it's important to look at this sheet on a daily basis to know which ones you have the opportunity to redo. You know which ones met. You know which ones are disenrollments that are going to be coming down the pike for you that might be an appeal. Now, there's one other column to the far, far right. That's an important column for you as a plan also. It says not yet submitted. That means for some reason you received a notice from us that one was due and you didn't submit it. It could be a tracking way for you to keep track of the ones that got missed somehow through the process. So this is the new system for informing you about immediately whether the person meets or doesn't meet, gives the plans the opportunity to make corrections to them, and gives you the results of the secondary reviews by DMAS and which individuals will be disenrolled. This is the first of 2 emails that you will get on a daily basis. The second email that you'll get on a daily basis is one that you have been getting already. This is a report that you're currently getting on a daily basis that lets you know ones that didn't get submitted in a timely manner, giving you the opportunity to turn in ones that weren't submitted timely and get an out of compliance notice, which you receive 5 business days to complete and submit information. Then if for some reason you do not submit the out of compliance time frame, then you get the delinquent notice, and then there's 3 days associated with that. So these are the 2 critical emails that all the plans will be receiving on a daily basis that keeps you abreast of what's happening within the LOC process. Again, you may not have absorbed all this information, but we are videotaping this and you can play it back at any time once we get it on the website after Thanksgiving. Now that I've explained it thoroughly to you and you sort of understand it, when is it all going to start? Mark your calendars. This process will begin on December 1st. So look for it in your LOC mailbox. So again, this goes back to a critical point that we've talked about many of our trainings. Be sure each plan has a concrete system for individuals that will check the LOC box and distribute the information around to all of the care coordinators. This is particularly important now with some of the time frames that are necessary that have to be met. All right, moving on to another hot topic. We probably received 2 or 3 emails since yesterday morning regarding this in an indirect manner or not. It has to do with open enrollment and the possible issues that are going to be created. This, we're trying to provide you some guidance and some information and support so that you can complete all of the LOCs that are due by December 31st for your plan and give you as much early warning as we can for the new plan that absorbs the individual that they're transitioning in on. So, what are the plan's responsibilities? They're really quite simple. We're responsible for the member change plans. If the LOC is due before December 31st, the current plan is responsible for the completion of it. Now, if for some reason you're running a little late and it runs into January, you're still responsible for it because you were the lead plan for that individual, providing them the services during the month of December when it was due. If the LOC is due in January 1st, the new plan is responsible for completing that. Now, we recognize not very many people will have an LLC due on January 1st, but there's going to be a few people that are going to be needing to be done before the normal list that gets shipped out to you, telling you the list of every individual that you have in your plan for that year. So DMAS is going to kind of provide a little bit more leniency for these individuals that are transitioning to a new plan that you can have till the end of January to complete those people. That's not everyone that's due in January. That's just the people that are transitioning in. All right, what is DMAS going to do to support you in this? Well, DMAS is going to be sending out lists of confirmed transfers. We're going to be doing this near the end of November and then mid-December. We're hoping this will allow the plans time to plan for early January LOCs. Now, for the plans that have individuals due in December, you should know who they are now, because the October list gave you 60 days notice of that early period, which is all of November and all of December, to complete the LOC. So it's really a matter of your picking the timing and trying to do them as best you can. And in reality, you help yourself by doing them a bit early, because you don't want to have to go out the day after Christmas to try and do one of these. You know, just make it easy on yourself if you can. All right, moving on to another topic. Appeals are growing. The LOC team is appreciative of the support that the plans have been providing them in the appeal summaries, as well as defending appeals. You need to know that we have 23 active appeals right now. We've already completed 8 since July. Now, that doesn't seem like a whole lot, but that's 3 to 4 times more than we did in a full calendar year prior to the implementation of CCC+. So it is something that we sense might be a concern for you all as a plan. So we're going to take a minute or two here and kind of walk through the process of an appeal and some responsibilities. Once we've completed the LOC process, you can see that there is not letter appeal rights. If you move over to this blue dot, it says the LOC team will disenroll the individual. That's in the MMIS system. Then if you go down to the green square with the black lettering, if the individual does not appeal, that is the end of it. The person is out of the waiver, the process is closed. However, if the person appeals, which is the individual box with the yellow lettering in it, that starts a whole new process. That process is that an appeal has been submitted to DMAS. Please note, all appeals must come from the individual and go directly to the appeals division. It cannot come from a plan. It has to come from the individual. The LOC team gets notified that there's been an appeal. The LOC team will go back into MMIS and re-enroll the individual. The LOC team will then begin to compose the appeal summary. The plan, care coordination, and the care coordinator who did the LOC will be contacted to help develop this appeal summary. If the individual wants to continue their waiver services during the appeal process, they can do that. However, that individual, again, must be the one to submit that request to the appeals division. The plan cannot do it for them, okay? Okay, now we have an appeal. We're working on summarizing the appeal, the defense for the decision, and the hearing division sets a date. They set that date mainly to the convenience of the individual and the appeals division, not necessarily the LOC team or the plan. So we have to be on our toes and be ready to be at the hearing when it is. The hearing actually is held. It is a formal legal kind of hearing. Individual participants have the right to have legal counsel at the hearing, which means your testimony can and will need to be able to tolerate cross-examination. And then the hearing officer will make a decision, which is the red triangle with the black letters. The appeal decision is typically made in 30 to 45 days of the hearing date. The appeal decision can go 2 ways. The decision can be reversed and waiver services will continue for the individual. That's the left column. If the decision is upheld, the LOC team would go back into the MMIS system and disenroll the individual, and waiver services would end unless a second appeal is applied, which is to circuit court. We don't have very many of those, so I won't go into that at this point in time. Occasionally, information that is gathered during the appeal summary drafting and at the hearing, it gets presented that can allow us to do administrative settlement of an appeal and allow services to continue. But that happens not that frequently, but it does occasionally happen. That depends on the situation. Some helpful hints for you. All the LOC appeals go directly to DMAS because DMAS is the discharging entity, okay? The appeals must be requested by the Medicaid individual, which I've said before. The individual must also request a continuation of services to the appeals division, again, not the MCO. The health plans or the MCO will be asked to provide updated data on the ADLs and medical necessity, and this information would be included in the appeal summary. The appeal summary is summarized and drafted and submitted by the LOC team, and then the healthcare plans number 5 would be submitted, subpoenaed to attend the hearing. During this hearing, the plan would respond to the hearing officer's questions and present evidence to support the appeal. Typically, the plan's attendance at these hearings is by phone. You do not have to be there in person. Some other ongoing concerns that we've noted as we've been over the last couple of months, the questions come up. Are the annual LOCs always due? Is there any issues with EPSDT in the waiver as far as annual disenrollments or annual LOCs for to be completed? Some disenrollment reasons, confusions going on. Some timely responsiveness of the plans and daily emails. So let me talk a little bit about some of those. Is the LOC always due? Well, the LOC is a federal mandate. It's a state regulation, and it's required by CMS for 100% completion of an assurance. So I think the answer is yes, it is always due. There's no reason that we can honestly accept that they can't be done. If they're enrolled in the waiver, the LOC has to be done. If you need to, look at the annual LOC as the way of guaranteeing the person continues to meet the services. And that's done on an annual basis. Just to help you, the LOCs are based on the annual, they're done annually within 365 days of the initial enrollment or a re-enrollment in the waiver, and every 365 days thereafter of their last face-to-face review. To give you an example, if you do it in the 60-day early period, that moves the date to a little earlier time for the next. EPSDT. So EPSDT and waivers are really a partnership in providing services. What it boils down to is that if an individual under the age of 21 is receiving EPSDT, which is private duty nursing, personal care services, and some other services, and they're having a service authorization for a CCC Plus waiver service, they may exceed 30-day break in services. However, eligibility regulations require that a 225 still is required to be submitted because of the break in waiver services. If this break in service occurs, it must be noted in the Medicaid, the medical nursing need comment box on the portal. The notation should include that there is a valid service authorization for CCC Plus. What we're saying here is we would like to have some kind of documentation in the LOC file when you submit the annual LOC, why the person had the 30-day break of service as it's related to only EPSDT. So all in all, anyone that's an EPSDT and the waiver has to have an annual LOC every year. Here's some interesting disenrollment reasons that we've received. You'll find some similarities and things. Now, I apologize, you may see some typos in here, some other kinds of things in here, but that's because this is literally the way we received them, and we felt that you ought to just kind of see what we deal with. CC was unable to meet with the member prior to LOC due date. However, the LOC appointment was scheduled for. Okay? And a little bit of conflict there about what's going on. Okay, members unable to meet before the LOC deadline date due to his guardian being sick. Home visit to complete the LOC has been scheduled for. Failed attempts to reach the member to complete an assessment, drive-bys, calls, letters, above addresses, phone numbers. CM will continue to reach out to the member to complete. Okay, well, here's some common threads that might help you resolve this. One, visit when the services are being delivered. That goes to the bottom bullet. Use the network provider if you're missing the person. You all within your service authorizations, you all within the plans know if these people are actually receiving services. So if they're getting morning care or they're getting evening care, go there when they're receiving the care. It just seems logical that if the person's receiving the care, they're going to be home, therefore they can be found. Also, this is the opportunity for you to work smart and use that 60-day window and not wait till the last 2 weeks before the LOC is due, and that would help avoid those first two kinds of bullets. Two more examples. Members unable to be seen by a local due date. 3 outreach attempts to date will continue to attempt to locate the member. No services received for greater than 30 days, unable to locate the provider. Should, in many respects, like it says, unable to locate provider, this really shouldn't be occurring based on your service networks and the CCC Plus contract. Therefore, we're strongly encouraging you to contact the care coordination unit to get support and help for those kinds of issues. All right, daily emails. I'm going to sound a little bit like a broken record here, but I think it's important some of these kinds of things are repeated because it really can make a difference overall. We've been getting emails in the LOC box saying we're not getting things. Well, what's happening is multiple people are going in and checking. It's getting deleted. So daily checks are important, and consistent checks from one person or by one time or something like that is what's important. The second component is to be sure that the information gets distributed to the care coordinators. When you were only receiving notifications on the 26th of the month about monthly updates, you only had to do it once a month, but now with the new not met penned category and the out of compliance and delinquent list, it's really almost a daily occurrence that you need to be sure to take care of. If I may digress for a second here, one of the other concerns that we had was when is some of the information going to be distributed? Please recall from all the prior training sessions, CMAS had set up about the middle of January that a master annual list would go to the plans for the purpose of just giving you a clue to plan when and how you would get your LOCs done. Then on the 26th of the month, you would receive an update to that, giving you the individuals that are due within the next 60 days. So essentially, you get at least 3 notifications for every single person in your plan. Now we're adding, as I described earlier, that end of November and the December notices for transfers. So there's an ongoing array of information coming to you in terms of when people are due and who are due and that type of thing. Use of cell phone connections. We've recently learned that sometimes because you're all out in the field and all of our smartphones are really little laptops, you guys are able to go in and look at the emails and that kind of stuff from remote locations. Well, be aware of the fact that sometimes this can create an issue with your systems being able to get to our secure email. It may create some issues in terms of the way it gets, like it'll connect, but it won't show on your screen, which then counts against one of your counts for getting into the secure email opening. So just be very cautious of that and double check with your own internal systems if there's any issues there. 6 months ago, we had to change secure email system. And in doing so, as you all know, every email has its own secure password. Also, there is a limit to the number of times you can open any attachment that's on that. And that's why I go back to the daily check and a central person or a single individual to do the opening of these emails to avoid things. Also, be aware of the fact that we get read receipts on all your emails that are open. So, if care coordinator 10 calls and says, I didn't get something, but we can go in and see that care coordinator 1 and 2 got them, then the distribution is not happening within your plan. So this is an example of an email that comes to you. If you look down here at the bottom where the arrow is, my arrow is working again finally. This tells you, if you click on this, you'll open an Excel spreadsheet that will give you the information regarding the individuals. Now my arrow disappeared. Oh, here it is. Then over here, it'll tell you how many times you have left that you can open that particular file. So if it says 0, yeah, you're not going to get the information. The email is going to be there, but the information is not going to be. So it is important, again, centralize and monitor that kind of stuff to help yourself better avoid confusion. As always, we try to end, and I am at the end of this presentation, other than some questions and answers, which we've got about 10 or 15 minutes left, on scoring improvements. We want to say and let you know we are very pleased to announce that there's almost a 20% drop on the functional not met errors for people not meeting. That's a huge jump. So somewhere along the line, the training that you all have been doing individually, the training that's been happening, seems to have an effect that you all are making better decisions regarding the functional criteria to meet. The other 2 percentages are real close to what they were before, so we're not too much worried about that. But we do think that we wanted to share the positive news with you so that you could know what's going on. That concludes what I had to present. We have 7 minutes left, I've been told. Do we have some questions in the chat box that I can begin to answer? And if we can't get to all of them, we will send something out answering them afterwards.
There is one chat box. Is an active respite authorization to avoid a break in services and therefore avoid sending 225 every month for members who base their respite summertime, etc. Since DMAS care coordination has said on multiple occasions that a respite authorization is sufficient, even if there's not using, would it be appropriate to submit a discharge level of care by the due date if a member cannot be located? They have no waiver providers or authorization, and all other avenues have been exhausted to locate the member.
There's a couple of folks from Care Coordination Unit in the room. Could you all help speak to that question of the number of services or respite services?
Is the caller talking about folks that are receiving EPSBT services? Or the person who's in the chat box?
Yes, it says it would be appropriate to submit a discharge LOC by the due date if a member cannot be located. Would you like me to repeat the question? First question. No. Okay, the first question. Is an active respite authorization is sufficient to avoid a break in service and therefore avoid sending 225 every month for members who base their respite for summertime, etc. Since DMAS care coordination has said on multiple occasions that a respite authorization is sufficient, even if they're not using respite hours monthly. Okay, we need some clarification. So the person who's asking that question, if we can get you to unmute your line, you can go ahead and address your question so that we can simply get some clarification for you.
As long as that client is a child under 21, they're receiving EPSBT services for private nursing or personal care or consumer-directed care, then the respite is the waiver service that they have that is keeping them in the waiver. Although they may not use it, it is fine to keep that patient open to waiver services with that open respite authorization. As far as sending a 225 to Department of Social Services each month, the rule is if the person goes over 30 days without waiver services, if you're not going to discharge them, then you send that $225 to Department of Social Services for a financial redetermination. If I were, I'd call the social services in the county where that patient lives, I would explain to their worker that because they are going to not use their respite on a monthly basis according to the guidelines, you're going to send that 225 to them. And then they will tell you what to do accordingly.
Thank you very much. I apologize. We are running out of time. Our internet connection is going to come to close in about a minute. So let me just conclude by thanking you all for participating. We apologize for some of the technical difficulties we had getting going. We will, like I said earlier, make this available after Thanksgiving web so that it can be reviewed.